Hello, this is a Harlan Institute FantasyCast for Snyder vs. Phelps. I'm Josh Blackman. On October 6, 2010, the United States Supreme Court heard arguments in the case of Snyder vs. Phelps. This case considers whether the First Amendment protects the protests of the Westboro Baptists who picketed at the funeral of slain Marine Matthew Snyder. In this podcast, we will highlight some of the key exchanges at oral arguments. The attorney for Albert Snyder, the father Marine, opened up by arguing that the rules pertaining to protests at funerals should be simply different.
We're talking about a funeral. If context is ever going to matter, it has to matter in the context of a funeral. Mr. Snyder simply wanted to bury his son in a private, dignified manner. When the respondent's behavior made that impossible, Mr. Snyder was entitled to turn to the tort law of the state of Maryland.
Justice Scalia jumped in to inquire whether there was one cause of action or two.
You either have two separate causes of action. One is the intrusion upon the funeral, and the other is the harm caused by viewing this posting on the internet. But I don't see how they both relate to intrusion upon the funeral.
Justice Alito questioned whether the protests were directed directly at Matthew Snyder or in fact they were directed at the broader issue of the war.
Well, yeah, but the signs say you, and the argument is made you doesn't mean Matthew Snyder, it means a larger group. And then you have the epic, which is directed directly at Matthew Snyder. Doesn't that shed light on what you meant on those signs?
The protesters were standing approximately 1,000 feet away from the ceremony. Justice Breyer asks whether Mr. Snyder in fact actually saw the protesters and their signs.
Did your client see the signs? I gather from the record he didn't see what the signs were. He just saw tops of signs. So he didn't read anything on the signs. Is that right?
He didn't read the content.
No, so he hadn't seen it. So how did your client find out that the signs, the tops of which he saw at the funeral, when the demonstrators were standing with the approval of the police 300 feet away, right, how did he find out what they said?
Because Snyder never actually saw the signs, Justice Breyer inquires what the standard should be about disseminating this information on the Internet, for example. He knows that this standard troubles him.
Okay. So now we have two questions. One is, under what circumstances can a group of people broadcast on television something about a private individual that's very obnoxious? And you, because of the funeral, you say that I accept that. From your point of view, that is very obnoxious. And the second is, to what extent can they put that on the Internet, where the victim is likely to see it, either on television or by looking it up on the Internet? Now, those are the two questions that I'm very bothered about. I don't know what the rules ought to be there. That is, do you think that a person can put anything on the Internet? Do you think they can put anything on television, even if it attacks, say, the most private things of a private individual? Does Maryland's law actually prohibit that? Do we know it does? And what should the rules be there?
After this long string of hypotheticals, Justice Breyer whimsically asks,
have I said enough to get you talking?
Intrigued by the answers he's receiving, Justice Breyer sought more information.
The more you say about this, the happier I'll be, because I'm quite interested.
Justice Kagan inquires about Hustler v. Falwell and asks whether the standard that Snyder seeks would permit regulations based on the content of unpopular speech.
Mr. Chambers, Hustler seems to me to have one sentence that's key to the whole decision, and it goes like this. It says, outrageousness in the area of political and social discourse has an inherent subjectiveness about it, which would allow a jury to impose liability on the basis of the juror's tastes or views, or perhaps on the basis of their dislike of a particular expression. How is that sentence less implicated in a case about a private figure than in a case about a public figure?
Perhaps trying to split the difference, Justice Scalia offers a possibility of ordering a new trial in this case rather than deciding it on the merits.
So, Mr. Summers, can I ask you, suppose I don't think you have a cause of action for invasion of privacy when these people were at this distance from the funeral, but that was one of the causes of action submitted to the jury. If I disagree with you on that cause of action, I suppose I'd have to say there has to be a retrial now.
of course this court could do that.
Margie Phelps, a member of the Westboro Baptist Church and a relative of Fred Phelps, argued the case on behalf of the respondent. Phelps actually argued that the protests were, quote, circumspect.
Mr. Chief Justice, and may it please the court, when members of the Westboro Baptist Church entered an ongoing, extensive public discussion and wide array of expressive activities taking place in direct connection with the deaths and funerals of soldiers killed in Iraq and Afghanistan, they did so with great circumspection, and they did so with an awareness of the boundaries that have been set by the precedents of this
Justice
court.
Scalia spent some time inquiring about the fighting words doctrine. Perhaps this is a hint that he sees the protest as a form of fighting words, that would be unprotected speech.
My goodness, we did have a doctrine of fighting words, and you acknowledge that if somebody said, things such as that to his face, that wouldn't be protected by the First Amendment. Is it the criterion of the fighting words exception to the First Amendment that there be an actual fight? Certainly not that. Is it a requirement that there be a potential for a fight? I doubt it.
Justice Ginsburg cuts to the heart of the matter and asks why the First Amendment should protect this exploitation of a bereaving family.
And the question is, why should the First Amendment tolerate exploiting this bereaved family when you have so many other for getting across a message the very same day you did?
Justice Alito, who Jan Crawford referred to as a one-justice Delta Force, asked a probing question about what would have happened if the protesters had accosted Snyder's grandmother as she was waiting at a bus stop following the funeral.
One example. Let me give you another example along the same lines. Let's say there is a grandmother who has raised a son who was killed in Afghanistan or in Iraq by an IED, and she goes to visit her grandson's grave, and she's waiting to take a bus back to her home. And while she's at the bus stop, someone approaches and speaks to her in most vile terms about her son. He was killed by an IED. Do you know what IEDs do? Let me describe it for you. And I am so happy that this happened. I only wish I were there. I only wish that I could have taken pictures of it. And on and on. Now, is that protected by the First Amendment? There's no false statement involved, and it's purely speech.
Right. And it may give rise to some fighting words claim depending on the proximity and the context. And I would have to know.
Well, it's an elderly person. She's really probably not in a position to punch this person in the nose.
She's a Quaker, too.
Even under Justice Scalia's Quaker grandmother theory, counsel had no answer to that question. Next, Justice Alito inquired as to whether the funeral was in fact a public or private event.
To say that my hypothetical is different because Mr. Snyder made his son into a public figure. And the question I wanted to ask in that connection is whether every bereaved family member who provides information to a local newspaper for an obituary thereby makes the deceased person a public figure.
Justice Alito inquires whether criticizing someone based on their race would be appropriate because it is a matter of public concern. To this, Ms. Phelps proposes the, quote, get up in your grill theory of privacy.
Let me give you this example. Suppose someone believes that African Americans are inferior. They're inherently inferior. And they're really a bad influence on this country. And so a person comes up to an African American and starts berating that person with racial hatred. Now, is that this is just any old person any old African American on the street. That's a matter of public concern?
I think the issue of race is a matter of public concern. I think approaching an individual up close and in their grill to berate them gets you out of the zone of protection, and we would never do that.
In his only comments of the day, Justice Kennedy makes a lengthy remark about pluralistic societies and components of identity.
That simply points out that all of us in a pluralistic society have components to our identity. We're Republicans or Democrats, we're Christians or atheists, we're single or married, we're old or young. Any one of those things you could turn into a public issue and follow a particular person around, making that person the target of your comments, and, in your view, because this gives you maximum publicity, the more innocent, the more removed the person is, the greater the impact, the Justice Alito hypothetical in the grandmother case. So I think your public concern issue may not be a limiting factor in cases where there is an outrageous conduct and where there should be a tort.
Justice Scalia returns to the fighting word standard and argues whether this is in fact a more or less subjective standard than the IIED standard.
Well, let's talk about subjectivity. You're concerned about something. Surely fighting words is, whether something's a fighting word, that's a very subjective call, isn't it?
I believe that your cases give some good light on that, Justice Scalia.
You don't think it's subjective?
There may be in some people's mind an element of subjectivity. My 20 years.
You think that's solid? Oh, absolutely. What's a fighting word? Whereas what is an outrageous statement is very much different from what's a fighting word.
Well,
I don't see the difference. Besides which, isn't it the case that in order to recover for the tort of intentional infliction of emotional injury, you have to substantiate the injury with some physical manifestation, which the plaintiff here had. And my goodness, for fighting words, you don't even need that. You can just say, these words angered me to the degree that I would have been inclined to fight. At least for this tort, you have to have physical manifestations. Why isn't that a very objective standard?
Justice Breyer, in his attempt to balance active liberty and make our democracy work, is looking for a way to protect free speech, but at the same time not protect the kind of egregious speech in this case. Even he notes this might be an impossible task.
So what I'm doing is suggesting a number of thoughts, of ways of trying to do what I'm trying to accomplish, to allow this tort to exist, but not allow the existence of it to interfere with an important public message where that is a reasonable thing to do. Now, maybe this is impossible, this task, but I'd like your thoughts on it.
Towards the end of oral arguments, Chief Justice Robert cuts to the issue. The reason why the protesters protest at funerals is not because they're public events, but because they know if they do so, they'll obtain maximum public attention.
He does nothing. He does nothing other than bury his son.
Right.
He is then not a public figure.
He does nothing. We don't picket him. And
well, that's because if he does nothing and it's not publicized, you don't get the maximum publicity that your clients are looking for. My question is, that if he simply buries his son, is he a public figure open to this protest or not?
Thank you for listening to this FantasyCast. For more information, please visit harlaninstitute.org or fantasyscotus.net.